what most people then default to is going domestic. It's cheaper to start up. You're going to be in control of your assets. Problem is they suck on effectiveness, and they're starting to get pierced because we have what's called a constitution. Article 4, Section 1, full faith and credit clause, meaning if I own, a California piece of property and I have a Nevada LLC, I can't take that judgment, go to Nevada, and Nevada say like, hey, sorry, we're not going to exercise that judgment. They legally have to, adhere to that judgment and even litigate the case because you have to give the full faith and credit to other states, judgments and recognitions. And then you have crazy judges nowadays that are just, litigating from the bench. And so you have radical judges now not following case law and statutes and using their superpower called public authority, public policy. And so the way you combat this is you want to take the best of both worlds. You create what's called a hybrid trust or a bridge trust. And you take an offshore Cook Islands trust and you domesticate it through the IRS. And now it's cheaper to start up, it's cheaper to maintain. You have no IRS disclosures whatsoever.
This really is a trial attorney because you're referring to case law. The second I hear that, I'm like, okay, that's actually a person who is going to end up being in court and knows this from a practical standpoint, not just a theoretical standpoint. I always noticed that when I worked in law enforcement, those of us that were in court testifying had to pay a lot more attention to the case law involved than those that never did it.